From the Daily Maverick, their newsletter to their subscribers, of which I am one. Hi there, thanks for sending us your NHI questions. The passage of the law has caused anxiety for those concerned about what it means for private care, and some excitement for those who see the potential for social justice. Today, we want to stress an important fact. The law's implementation is years away, and its final implementation, when the truly big changes happen, is 3 decades away. Information is important and understanding vital, but worry is not. And that 3 decade is based on something from the National Treasury's Mark Bletcher, who leads the Treasury team in health financing. And he told the Financial Mail this week that he thought it would take 3 decades to fully implement the NHI. And the newsletter also says what is clear is that various parts of the law's implementation will be taken to court by various bodies, and that finalization of those battles will also be drawn out. So it is going to be business as usual for quite a while yet. What about the chances of success for the various challenges which various political parties and other stakeholders in the medical aid field, not medical aid, it's medical aid, Board of Healthcare Funders, it's the AfriForum interest body, a whole lot of people saying, we're ready, BUSA, Business Unity South Africa. Professor Pierre de Vos, Professor of Constitutional Law at UCT. Pierre, you write earlier today, also on Daily Maverick, that you're not convinced that any of the potential challengeable areas have an obvious chance of success.
Yes, so not any of the potential areas, but the ones that are essential to the operation of the system. The first problem is that as the law stands, it is actually quite vague. So how it will actually work and its impact is probably only going to become clear if when it is implemented, or if it is ever going to be implemented. So to make claims that your rights are infringed based on projections or speculation about what might happen in the future, it might not work. So that's the one thing. The other thing is that people are invoking rights like the right to property, which I don't understand why, the right to freely enter into a trade or occupation. And nothing in the law seems to me to make it at least absolutely clear that these rights are even implicated, let alone infringed. For me,
because one of the things, sorry to be interrupt here, but one of the things I've heard is I have a right to choice, and this will take away choice from me, where to send my ailing body.
Yeah, there's no right to choice in the Constitution to a specific way of accessing or arranging for a specific way to pay for medical fees. So I'm not sure what that right to choice would be linked to. Maybe I haven't thought about it long enough, but I can't think of a right that will be infringed. The closest maybe the right to dignity, but it's a long shot. Maybe the argument I think that might potentially have some bite to it is the argument that if the system is going to reduce the ability of people who currently have access to medical aid to quality health care, then it might be a retrogressive measure, an infringement of the right of access to health care, because it takes away your enjoyment of an existing right, although it tries to give more of that enjoyment of that right to others.
But doesn't that fall into the same empty basket as what you said earlier, that it anticipates what we know to be the case, that under this government the NHI will be a total failure and everybody's health care will either be just as bad or worse than it is at the moment? But can you say in a court of law, as you indicated earlier, that we know this is going to happen because this government can't even run the post office, so how's it going to be able to run the NHI? Is that a constitutional argument?
No, I don't think that in itself is a constitutional argument. One can take into account, and the court take into account the larger context. So, South Africa, inequality, history, all of these things, the fact that there is a strong medical scheme system established, all of those things the court will take into account. But of course, the government changes. So it never explicitly takes into account that this particular government is corrupt, and therefore the law will have this effect. Yes. So
and then
the
Pierre,
other problem is, of course,
the issue of consultation, because that seems to be at least one of the areas in which the DA's challenge will lie. That public consultation was a tick box exercise and nothing more.
Yes, so I looked at the minutes of the portfolio committee. There were public hearings in every province in South Africa. There were oral hearings in Parliament. So I'm not sure the argument which you have to make is that Parliament did not take reasonable steps, given what they normally do, to facilitate public involvement, because there was public involvement. It sounds like the argument is the makers of the legislation did not adopt or accept the criticisms and complaints from people who are critical.
Would the people who argue this have to prove that comments from the public and interested bodies was ignored, or would the government defending the case have to prove that they did in fact meaningfully engage with the comment that was offered?
Yeah, I don't know if it's an issue of proof. The thing is that if there's evidence, so the people who come to court will have to bring some evidence on which to base this. If they show that none of the provisions or arguments were accepted, it's irrelevant, because the Parliament does not have to accept any of these things. If they show that there were 50 or 100 submissions made, substantive submissions made of hundreds of pages with complicated arguments, and these were locked up in a box, maybe that will get them over the line. But I'm not sure exactly what the factual basis would be for this argument of a failure to facilitate public involvement.
So if you don't like the NHI bill, either on the 29th or in 5 years' time, vote the ANC out and replace it with something better.
Well, that is, of course, we don't even know if it's going to be implemented. The act hasn't been brought into effect. And after the election, we will see what the new government say. If they choose not to go forward, not to implement or bring the law into effect, that's also a possibility. Or Parliament can, of course, always repeal the law or amend it or whatever.
Professor Pierre de Vos, Claude Leon Chair in Constitutional Law at UCT. Thank you.